Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. All right, one of the things we're going to get into today is that of a main practice. The main topic, in fact, is that about trust planning. We're going to get into some basic trust planning, maybe a little bit, if we have time, some advanced concepts. Understanding one of the benefits and one of the reasons many people will use trust is that of avoiding probate. So what exactly is probate? Basically, this is where the objectives of probate would be to resolve any disputes. So it's kind of a forum where people can come in. There's a public notice that's put in the papers typically. And this is and creditors have to be notified when someone's passed of their passing so that they can file a claim to get paid back. The resolving disputes is someone saying, hey, that person owed me money. This is a forum for them to come forward to make that claim. Again, paying of creditors, formally inventory your assets of the estate, appraise those assets, change title to those assets, and distribute one's estate. So this is the thing, if you think about it, when you own those assets, right? They're in your name. When you pass, how do we get those into someone else's name? Now, if it's husband and wife and you've got joint ownership, right, then it automatically, by contract, just passes to the survivor. However, when the survivor then passes, right, that all those assets, real estate, whatever it might be, that is in your name, right? Now, how do we get that over to who you want to leave it to? We got to be able to change the name on those accounts. And that's not something you just readily do. I mean, during your lifetime, you can go change anytime you want, but when you're gone, right, and it's a protection, of course, for those to be legally transferred to who you want to leave it to, that's where the courts come in, typically with probate court, to change the title, right, over to this who's going to be inheriting it, or may go into another. Typically, in fact, when someone passes and we're looking at administering an estate, right, what we're doing is we're gathering all the assets, maybe selling everything. Selling everything off, for instance, is one common thing, and then take those proceeds and just write checks to everybody. That's one way it gets done. Or someone might say, you know, I want to keep that house. So, okay, we just need to then change the deed to your name, right, to the person that's going to inherit it. So that's part of the probate process, and this can be, you know, typically 6 to 12 months. It takes a little bit of time. There's notices that have to be given, and then depends on the estate and the complexities involved and how many people and are there any disputes. So typically, as I say, 6 to 12, but potentially we've seen probates drag on for even years, in particular where there's some conflict or disputes going on. So all things to remember when it comes to your estate planning then is understanding that if you have a will or you have God forbid you have nothing done, right? Because intestate, meaning if you die without a will or a trust or anything and it's just hanging out there, in a situation like that, the state's laws, they have a plan for you, right, of what's going to happen. Typically it might be, you know, and for husband and wife, there's something to keep in mind. Husband and wife get some kids, and one passes. If you don't have if you don't have your house in order, now joint ownership, as I said, can pass things, you know, by that means, but other assets, if they're in the name of the deceased spouse and there's no will or anything, then the courts, the way the laws work here in Tennessee, it would be divvied up between the surviving spouse and children. So that means you might be, and for most of us, that's not what we want, right? We want our assets go from, stay with the couple first, right? So when one passes, we want everything to go to the survivor. And when they pass, then it goes to the children. I mean, you may make some gifts, you may have to do some other things, but for the most part, we want to maintain control of our assets during both our lifetimes for a couple, not just at the first passing. So again, this is where having a plan is so important. So now if you've got a will, or as I said, even without a will, you're going to go through probate. And in probate, to prove the will is part of what happens, basically to look at the document, make sure there's only one will, that there are not other wills out there. Powers of attorney no longer apply, right? Those go away. So in probate process, what we're doing then, or what the court's doing then, and you're going to need an attorney, and you're going to need to do filings, so you're going to have costs involved with probate. Now, depending on the attorney and the county as to what those costs might be, but statutorily, if you look at the regs or the law on it, it could be 1 to 3% would be considered reasonable on the value of a estate. So if you've got a $1 million estate, you could be talking, anywhere from $10,000 to $30,000 potentially in probate. Again, depending on the attorney and the county as to what that's going to be. So this is something that understanding for the most part with probate, a will is a lot less expensive up front, but with the cost of probate added on down the road, it becomes more expensive than, let's say, if we do a trust. And if you have a trust and it's properly funded, and we'll talk about that more today about how to do that and how to maintain it. But if you do that, then you can, this one of the advantages of trust is you don't have to go through probate. And one of the reasons for that, of course, is we're doing the changes up front during your lifetime. So we're going to talk today about uses of trust. We're going to talk about the types of trust that there are, advanced trust planning. We're going to get into then some conclusions and help you get your own house in order. If you've got estate planning documents already, I'm going to give you an opportunity to get those reviewed at no cost to you. And if you haven't, this is a great time to get that done. Again, this is not meant to be a comprehensive discussion of trust. There are entire college and law school courses that do nothing but discuss trusts and their uses. This is more of a basic overview of trust, and of course you need a good qualified estate planning attorney to help you with that. One of the things when we get into misconceptions of trust is that they're overly complicated or expensive, that they're confusing, only for the ultra wealthy, or time consuming, right? And the reality is, these common misconceptions are generally based on worst-case scenarios and feelings that are molded by the public and the press. In other words, not really true. True that trust can be all of those things, if not, depending on how it's done and who's doing it, but it doesn't have to be that way. They can be as simple as establishing a testamentary trust in a will to receive all the assets not otherwise disposed of in the will. Now, one of the things with a testamentary trust, and we don't typically get into those, if you're going to set up a trust, it really is just a matter of getting everything titled correctly, getting that trust funded, and by funded I mean it's just about transferring your assets into the name of the trust. Much the way that the probate court would transfer assets into the name of the new the estate or the new beneficiaries, who's going to receive those monies. Same concept. We do it in the trust, and then the trust language you're putting in there who you want to receive these things and how you want them to receive it, for that matter. It doesn't have to be just leaving everything outright. There's a lot of things you can do with a trust that can be beneficial both to you, help protect you and your beneficiaries in a number of different situations. So the fact about being complicated, not really. It's just, getting with the right attorney on that. Expensive. They are more expensive than a will, though not if you throw in probate costs, then they're less expensive actually over the long term. And they don't have to be confusing at all. In fact, they're relatively easy to work with. And as far as the ultra wealthy, my experience, the ultra wealthy, whether, sure, they're going to be utilizing this kind of planning as a means to minimize estate taxes, for one thing, which is certainly a benefit to them. But for most of us, it's not. If you think about it, if we have fewer resources and we're not really good stewards with those resources, we're more at risk. In other words, if you were to lose, say, 10 or 20 or 30% of your wealth, that could impact your lifestyle. Okay, whereas with the ultra wealthy, not so much, right? So if anything, I find that planning in general is more important for those that of more modest means as well. So time consuming, again, it is going to be more so than a trust, than a will, but it doesn't have to be anything that's going to. Basically, you want to get with a good planning. So for myself, and I work with attorneys, and what we're doing there is working together as a team. We do most of the work. You're not going to really be having to do much of anything other than the initial planning, the signing of the documents, and then the maintaining of it. All right, we're going to take a break. When we get back, we're going to have Jack McCann joining us here to talk more about basic trust planning. Join us here. We'll be right back on the Retirement Report.